We will review the immigration-related acts in Korea this time. In Korea, the immigration is regulated by various acts. Representative acts include the Immigration Act, the Nationality Act, and the Refugee Act. Other related acts include the Act on the Immigration and Legal Status of Overseas Koreans, the Act on the Employment of Foreign Workers, the Multicultural Family Support Act, etc. Let's learn more about the immigration-related acts in Korea. Among the immigration-related acts in Korea, the Immigration Act is the most important act. It was adopted first on March 5, 1963, and up to until 2021 has been amended 43 times. This suggests that the situation surrounding immigration at home and abroad changes frequently. The Immigration Act in Korea covers matters concerning the immigration of all nationals and aliens whom enter or depart from the Republic of Korea. The stay of aliens in the Republic of Korea and the social integration and the Nationality Act and the Refugee Act covers matters concerning nationality and refugees respectively. Matters concerning immigration fall under the jurisdiction of the Ministry of Justice, and technical issues are handled by the Immigration Office under the Ministry of Justice. Anyone who intends to enter the Republic of Korea from an area outside of the Republic of Korea or to depart from the Republic of Korea to an area outside of the Republic of Korea must undergo a departure inspection conducted by the Immigration Office. For nationals, the inspection is to confirm eligibility to depart the country in relation to military service or invoke prohibition of departure. The Minister of Justice may collect nationals' biometrics information or request a relation of administrative agency submission national biometrics information held by the administrative agency if necessary for entry and departure inspections. The Ministry of Interior and Safety can provide biometric information as it is required to collect relevant data such as fingerprints and photos when citizens apply for a resident registration card to the head of a local government. The Minister of Justice may prohibit a national from departing from the Republic of Korea for a prescribed period not exceeding 6 months for the following reasons. In addition, the Minister of Justice may prohibit a person from departing from the Republic of Korea for a prescribed period of time not exceeding 1 month if his or her departure from the Republic of Korea is deemed inappropriate in relation to criminal investigations, and the Minister of Justice may extend the period of prohibition of departure in any of the following cases. When an alien enters the Republic of Korea, he or she should hold a valid passport and a visa issued by the Minister of Justice. A visa is not required in any of the following cases. As of August 2021, Korea maintains no visa entry agreements with 108 countries. No visa entry agreements usually grant stays up to 90 days, but stays up to 30 or 60 days are granted to some aliens. And in the case of seaman certificates, the period of stay is usually 15 days. Every alien who intends to enter the Republic of Korea should be granted either status of stay or status of permanent residency. The status of stay is classified into short-term and long-term, and the details are as follows. The Minister of Justice may prohibit an alien from entering in the Republic of Korea if the alien falls under any of the following cases. And if the home country of the alien who intends to enter the Republic of Korea refuses the entry of a Korean national for any reason, the Minister of Justice may refuse the entry of such alien for the same reason. If an alien intends to stay in the Republic of Korea for more than 90 days from the date of entry, the alien should file an alien registration with the regional immigration service having jurisdiction over his or her place of stay within 90 days from the date of entry into the Republic of Korea. This does not apply in cases such as personnel of foreign diplomatic missions, and international organizations and their families. An alien registration certificate is issued and an alien registration number is assigned to each alien who has filed for an alien registration under the following items. The validity period of an alien registration certificate issued to an alien granted the status of permanent residency is 10 years. And a person issued a certificate of permanent residency should have it reissued before its validity period expires. The Immigration Act in Korea also provides deportation, investigations, detention, examinations, and filing objections, execution of written orders of deportation, temporary release of detention, and recommendation for departure. The Act also provides for searches of ships, responsibilities of captains of ships and forwarding agents, insurance of refugee travel documents, etc. In addition, various supplementary provisions, penalties, accusations, and notices are covered in detail. Next, we will review the Nationality Act. The purpose of this act is to prescribe the conditions for becoming a national of the Republic of Korea. It was adopted first on December 20th, 1948, with the current Nationality Act coming into force on January 1st, 2020 after 16 amendments. Nationality is one of the three essential elements that constitute a nation following territory and sovereignty. The Constitution of the Republic of Korea specifies that the qualifications of nationals should be stipulated by acts, and one such act is the Nationality Act. The methods of acquiring nationality in the Republic of Korea by acts are as follows. Acquisition of nationality by birth. Acquisition of nationality by acknowledgement. Acquisition of nationality through nationalization. Any of the following persons can be a national of the Republic of Korea by birth. An alien who is acknowledged by his or her father or mother who is a national of the Republic of Korea may acquire the nationality of the Republic of Korea by notifying the Minister of Justice, and the requirements are as follows. An alien who has never acquired the nationality of the Republic of Korea may acquire the nationality of the Republic of Korea by obtaining permission for nationalization. An application and required supporting documents should be submitted to a regional immigration office or a diplomatic mission abroad for nationalization, and the Minister of Justice decides whether or not to grant permission for nationalization. The requirements for general nationalization are as follows. Permission for facilitated nationalization may also be granted to an alien whose spouse is a national of the Republic of Korea and who falls under any of the following. Any aliens who desire facilitated naturalization should possess minimum basic requirements in order to support him or herself. In addition, there is also special nationalization. An alien falling under the following cases may be subject to naturalization even if he or she does not reside in the Republic of Korea for 5 years or more, has no status of permanent residency, is not even an adult, and not able to support him or herself. People who have contributed greatly to the Republic of Korea, meaning independent patriots and his or her families, those who have received medals or commendations from the Republic of Korea, or those who have made significant contributions to the national interest in a specific field. The Minister of Justice may allow nationalization for these people after review by the Nationality Review Committee. A person with multiple nationalities who intends to choose the nationality of the Republic of Korea within a period prescribed in the main clause of Article 12 may either renounce his or her foreign nationality or declare his or her intention to choose the nationality of the Republic of Korea to the Minister of Justice after vowing his or her intention not to exercise his or her foreign nationality within the Republic of Korea as prescribed by the Minister of Justice. A person who has acquired multiple nationalities before turning 20 years of age should choose one nationality before turning 22 years of age. However, there is an exception where the nationality selection period differs according to the Military Service Act. Next, we will review the Refugee Act. Any person who intends to obtain refugee status as a foreigner within the Republic of Korea may apply for refugee status through the Minister of Justice. Any person who intends to apply for refugee status should submit his or her passport or certificate of foreign registration, and if that is not possible, he or she should submit a written explanation statement thereon together with supporting materials such as reference documents for refugee status screening. A refugee applicant may stay in the Republic of Korea until a decision of recognition or non-recognition of refugee status is made final and conclusive through refugee status screening. When the Minister of Justice deems that an application for refugee status is well-grounded, he or she should issue a certificate of recognition of refugee status to the refugee applicant, or the Minister of Justice shall issue to the applicant a notice of non-recognition of refugee status, which states the reason of denial and informs the applicant that he or she may apply within 30 days. Such a decision should be made within 6 months from the date of receipt of the application. And a decision of non-recognition of refugee status may be made for any of the number of reasons, even if recognition is made that there are acceptable reasons for applying for the refugee status. Recognized refugees residing in the Republic of Korea are granted resident status and are treated in accordance with the Refugee Convention. In the Republic of Korea, a recognized refugee is covered by Social Security, basic living security, and education at the same level as the citizens of the Republic of Korea. An entry of his or her spouse and minor child is also permitted. The purpose of the Act on the Immigration and Legal Status of Overseas Koreans is to ensure overseas Koreans' entry into and departure from the Republic of Korea and their legal status therein, helping them settle in the host country by facilitating their domestic investment and maintaining ties with them even after they acquire a new nationality. Overseas Koreans are divided into Korean nationals residing abroad and foreign nationality Koreans, and each are defined as follows. The Minister of Justice may grant the status of sojourn as an overseas Korean to a foreign nationality Korean who intends to engage him or herself in activities in the Republic of Korea, except in the following cases. The period of sojourn under the status of sojourn as an overseas Korean is up to 3 years at its longest, and in the case of a foreign nationality Korean who has reported the domestic place of residence and who departs from and re-enters the Republic of Korea within the period of sojourn, a re-entry permit is not required, and the period of sojourn may be extended through an application and granted permission. The Act on the Employment of Foreign Workers was established as a device to systematically introduce and manage foreign workers to promote a smooth labor supply and demand for small and medium enterprises, to promote continuous economic growth of the national economy, and to protect the rights and interests of workers. The definition of a foreign worker is as follows. The Act on the Employment of Foreign Workers seems to apply to all foreign workers, but in reality, it only applies to foreign workers with an E-9 visa or an H-2 visa among the numerous foreign workers residing in Korea. Major matters concerning the employment management and protection of foreign workers are handled by the Foreign Workforce Policy Committee under the Prime Minister. An employer who has obtained employment permission for a foreign worker through a particular procedure must conclude a labor contract using the standard labor contract prescribed by the Minister of Employment and Labor Ordinance. And the employer can apply for a visa insurance certificate on behalf of the foreign worker. Every foreign worker shall receive training provided by an institution for making him or her acquainted with the matters necessary for working in the Republic of Korea after his or her entry. And the employer must not unfairly discriminate against the foreign worker just because he or she is a foreigner. purpose of the Multicultural Family Support Act is to help multicultural families composed of immigrants through marriage and their children to be better adapt to Korean society by overcoming differences in language and culture, resolving family conflicts, and providing better education opportunities for their children. The Minister of Gender Equality and Family establishes a master plan for policies on multicultural families every 5 years in seeking to support multicultural families. The following matters are included in a master plan. Also, a Multicultural Family Policy Commission under the jurisdiction of the Prime Minister is established in order to deliberate on and coordinate important matters regarding the improvement of the quality of life and social integration of multicultural families. The Minister of Gender Equality and Family may establish and operate general information call centers for multicultural families in order to provide multicultural telephone, counseling, and interpretation services, etc. And the state and each local government may establish and operate multicultural family support centers to perform the following duties. We have reviewed current immigration-related acts in Korea up to now. For more information, please refer to the website of the Korean Legislation Research Institute.